We will call our next case, Woodman versus the Department of Corrections. Good afternoon. This is a 15-minute mini oral argument on the application. Council, you may reserve some of your time if we do not use it up. We ask that you try to keep track of your own time, and you have 2 minutes of a free fire zone if you wish, or you may waive it.
Good afternoon, Madam Chief Justice, Your Honors. May it please the Court, Robert Riley and Dan Korobkin on behalf of plaintiffs appellants Spencer Woodman and George Joseph. If I may, I'd like to reserve 3 minutes of my time for rebuttal, and I'm happy to waive the initial free fire zone. There were 3 issues in the court's MOA order, and I'd like to start by addressing the second, the pro bono issue. That issue is whether the Court of Claims abused its discretion by reducing Woodman and Joseph's attorney's fee award by 90% based solely on Honigman's pro bono work, notwithstanding that court's findings that Honigman's hourly rates and the number of hours worked on these cases were reasonable. The statutory basis for attorney's fees under FOIA is MCL 15.240, subsection 6. And regardless of the prevailing party status issue, which I'll address in turn, whether a party prevails in full or in part, that statute has no limitation on a fee award to fees actually incurred. It has no distinction between attorney's fees charged by legal services organizations or by private law firms, and has no bar to recovering fees where counsel works pro bono. The court is well familiar with the analysis to determine a reasonable fee, and the touchstone, of course, is reasonableness, which is determined by the fee customarily charged in a locality for similar legal services, multiplied by the reasonable number of hours worked on a case. And neither of those factors are at issue here today. The MDOC did not appeal the Court of Claims rulings that Honigman's rates or the number of hours worked were reasonable. So once that initial lodestar figure, as it's called, is determined, Purgu v. U.S. Automobile Association allows courts to consider 8 factors to upwardly or downwardly adjust a reasonable fee. The parties briefed application of those factors in the Court of Claims, and the MDOC argued the applicability of each of those factors below during the hearing on plaintiff's fee petition. But the Court of Claims didn't cite any of those factors, or any other authority for that matter, for its 90% reduction in Woodman and Joseph's fee award. Rather, the Court of Claims' only reasoning was, quote, "these were pro bono dollars," unquote. So that leaves for this court the question of whether that ruling was appropriate, and we submit that it was not. This is one of those rare cases where I can confidently say, or at least more confidently than I could when I was in law school, that there is no authority, and the MDOC cites none, that supports the lower court's rulings here. To the contrary, the authority that we've cited in our briefs unequivocally and universally holds that pro bono representation has nothing to do with a reasonable fee award. And that really starts on command from the U.S. Supreme Court. In the Blanchard case, the court recognized that where there are lawyers or organizations that are willing to take a case without compensation, that fact doesn't bar a reasonable fee award. Then in the Blum case, which considered a statutory fee-shifting provision similar to Michigan's FOIA, the court held that Congress did not intend the calculation of fee awards to vary depending on whether a plaintiff was represented by private counsel or by a nonprofit legal services organization. More locally, in the Turner case out of the Sixth Circuit, the court held that it's well settled that the existence of a pro bono representation agreement doesn't preclude a reasonable fee award. So that's the baseline understanding that pro bono has nothing to do.
I'm having a hard time understanding your point about these cases. The cases don't hold that the pro bono nature of representation cannot be considered by a court in determining what a reasonable fee is, do they?
Those 3 particular cases, I believe, set the baseline that reasonableness determination and pro bono are not related concepts.
They say the award can't be barred for that reason. There's a lot of distance between no award at all and not considering the pro bono nature at all, isn't there? I mean, you could consider it, you could reduce it, you could think about it for different reasons. Our case law certainly allows, it's a non-exclusive list of factors, so it would be a factor a court could consider if the court thought it appropriate, but you're asking us to come up with a blanket rule that it can never be considered, and I don't see any court that's ever held that. Can you point me to one?
I can, in fact, Your Honor. I can point to 4.
Okay, what
So
are they?
the first would be the Kirk v. Arnold case out of the Illinois Court of Appeals, which reversed a trial court's denial of attorney's fees on account of pro bono representation, where the plaintiff was represented by Jenner and Block in cooperation with the ACLU. Obviously, that's directly analogous to this case. Honigman worked in cooperation with the ACLU. The second case out of the California Court of Appeals is Cruz v. Aramlu, and that court said that its research, like ours, uncovered no case in which a court reduced a fee award simply because of the pro bono work involved. The third case, slightly different circumstances, Lilly versus the County of Orange out of the Southern District of New York, categorically rejected a 5% reduction on account of pro bono representation. And then finally, I think the most important case, which we didn't cite in our briefs, and I apologize for that, but is the Blair v. Washington State University case out of the Washington Supreme Court, which held that the trial court abused its discretion in even considering the plaintiff's public interest representation. And that's 108 Wash 2nd, 558. So further to your question, you're correct that Purgu has 8 factors and it's a non-exclusive list, but the sort of catch-all at the end of those factors says that the other considerations have to be relevant. And I think the common thread from Blanchard, Blum, Turner as a baseline says that pro bono isn't relevant to determining a reasonable fee. But then we've got these other cases that explicitly hold that you can't downwardly adjust based on pro bono representation.
I just think there's a big difference between cases that talk about whether it's appropriate to bar the fee at all, or whether if it was only based, a reduction was only based on one factor. It still seems to me a distance from starting to take things off the list that courts can consider. Are there other things we've taken off the list of courts that courts can't consider in awarding? In other words, why would we limit the court's discretion in this way, the way that you're suggesting?
Well, I think the court absolutely does have discretion, and the 8 Purgu factors were actually at once 6 factors in the Wood case, and then that evolved into the Smith v. Curry decision, and now we're at Purgu. So the court's actually
we tried to streamline the factors in Purgu. Did we do a good job?
I think you did a fantastic job, and you didn't include pro bono.
So, counsel, I think, would your response to Justice Viviano be that there is discretion? It's, you get your fees, but that it's a question of what's the reasonable rate and what's the reasonable hours, not necessarily who was doing the representing. Is that an accurate?
That's correct.
Okay.
Among those Purgu factors, none consider pro bono. The success of the case, the kind of extraordinary circumstances. Purgu speaks for itself, but none of those factors contemplate, frankly, the attorney-client relationship and whether that was a pro bono engagement or a paid engagement.
And what are we to make? There was, recognizing the finding that the time spent in this case, the judge found that the time spent was fine. What are we to make of the notion that MDOC has raised about the amount maybe being higher because the attorneys at Honigman weren't FOIA experts, and so the hours are out of whack?
Well, I would say that they didn't appeal that issue, so that's not properly before the court. Okay. The Court of Claims determined that the hours and the rates were reasonable, and that's not properly preserved.
The statute clearly provides for legal fees, but do we, as a court, have the authority to say, if a firm says we're going to take something on pro bono, and there's a statute that provides for legal fees, those legal fees should go, for example, to the State Bar Foundation for access to justice?
Does the court have the authority to do that? Is that your question?
Yes.
Well, I'm not going to stand before you and tell you that you can't do something, but I will say that I don't believe that would be consistent with a client and their engagement, a contractual engagement with their law firm. I don't know that.
But you could have taken this case not as pro bono. You could have just taken the case and said, we'll take this case for you, and if we prevail, there's a statute that says we're entitled to attorney's fees. We lock up all those attorney's fees.
Well,
That could have been an engagement, and then there'd be no question here. But what makes this an interesting case is that the firm agreed to take it on pro bono. And I mean, I have no problem with the ACLU getting resources because everything they do really is in line with pro bono. They're seeking out clients who wouldn't otherwise have representation. But it strikes me as odd that Honigman can say, we're going to take the case on pro bono and then collect the attorney fee. It's really not pro bono at all. The American Bar Association defines pro bono as a program that matches low-income clients with volunteer lawyers who agree to take their cases for free. But if you're entitled to the attorney fee, it's really not for free, is it?
Well, Your Honor, I would actually say in this particular case, Honigman, in cooperation with the ACLU, donates the fees that it recovers in cases just like this to the organizations that it cooperates with.
All of them?
Yes, in this case, all of them.
So why can't we just say then, fine, we're going to say it goes to the State Bar Foundation. We think that's a better charity.
Well, I again don't believe that's an appropriate intrusion into the attorney-client relationship or the relationship between a private law firm and a legal organization service that it's decided to help.
But once you say you're doing it pro bono, doesn't that give us authority? Isn't that an indication that the firm has agreed to do this for free?
It has, but the legislature determined that FOIA allows a prevailing party to seek fees. Take the opposite situation. If we had lost this case, we have no expectation of recovering our attorney's fees. The ACLU wouldn't get any portion of them. Honigman wouldn't get any portion of them. So that's entirely our risk. But the flip side is the legislature did provide that mechanism for prevailing party, and the statute doesn't distinguish between paid counsel or pro bono counsel. And I think underlying your question is the notion that that paid counsel is somehow worth less than their nonprofit or pro bono counterpart.
They're not worth less. They're held in the highest esteem from my perspective as the chair of the Justice for All Commission because they're willing to do pro bono work. They're willing to put their high-priced lawyers to the good of the cause and do work for free. What I find troublesome is that it's really not for free.
Well, it is, but the legislature determined that if we win, it may not be for free in the sense that the MDOC has to pay fees, but that's not because the legislature determined that the firm should get paid. That's a deterrent to state agencies from not cooperating with their obligations under the Freedom of Information Act.
That same deterrent would work, though, if we say that the fee goes to the State Bar Foundation, wouldn't it?
It would. I just don't think there's a statutory basis or a common law basis for otherwise intruding into the attorney-client or cooperating counsel relationship.
Thank you. You've held up very well.
Well, and I think
Can you
we
switch gears to the prevailing in part? And I guess my question is, and I know your position is that you prevailed in full. If you didn't prevail in part, can you give me an example of a situation where prevailed in part would apply?
Sure. So at the outset, I would say that a party that prevails in part is entitled to the same fee analysis, in terms of reasonableness and the Purgu factors, and in our opinion that pro bono doesn't impact that analysis. So it doesn't matter from a fee perspective whether you prevailed in full or prevailed in part. I understand what you're getting at is, I guess, the element of discretion and when a court could award less than a 100% award. Is that a proper understanding of your question? So let me back up just a hair. In the Kestenbaum v. Michigan State University case, it was a 3-3 decision from 1982. So Justice Ryan's opinion that discussed this isn't binding on this court, but he said that in assessing what portion of a partially prevailing fee should be allocated to a plaintiff, he said that you should allocate the fees, quote, fairly allocable to the successful portion of the plaintiff's case. So in a hypothetical situation, actually, let's take the reality, our situation. We didn't submit any time entries or request any fees for litigating the appropriateness of the redactions. So we believe that all of our fees went to the successful portion of our case because we obtained all audio recordings and we obtained all videos. Perhaps in a different case, there could be a situation where a plaintiff spent hundreds of hours, or plaintiff's counsel spent hundreds of hours litigating an issue and ultimately lost and only prevailed on, receiving a couple of requests that weren't really related to the gist of their complaint. Maybe in that situation, the fees fairly allocable to the successful portion of their case wouldn't be 100%.
So if you had litigated the redaction, and let's say it was, 5% of the work that was done, the trial court could have looked at that and reduced fees by 5%?
Well,
If you had, been unsuccessful in litigating the redaction?
I would argue that it could not. Our Court of Appeals in the outdoor systems case said that the prevailing party inquiry does not turn on the magnitude of the relief obtained. Instead, a party must succeed on any significant issue which achieves some of the benefit of the party's lawsuit. And then there's a case we did cite in our brief, the New Jerseyans New Jerseyans for death penalty moratorium case, that said that a mathematical approach looking at a ratio of successful requests to unsuccessful requests is not the appropriate inquiry. It's the broader, did you succeed on the crux of your lawsuit?
And counsel, does it matter that your complaint in this case asked for unredacted info and the original FOIA request did not have that language?
I would say that it doesn't for a few reasons. And again, I'm respectful of my time here. So first, the Court of Claims expressly ruled that there were no security concerns with the videos and that the MDOC was to immediately disclose all of the videos. That was in its April 22nd, 2019 order, appendix page 332A. Then the court said in its May 30th, 2019 order that, quote, this court does not believe that there is any law precluding the display of the faces of public employee correctional officers, unquote. That's page 421A of our appendix. So the MDOC lost on the very argument that it now claims gave it a partial victory. So notwithstanding our complaints allegations, Woodman and Joseph declined to exercise their option to contest the redactions after the judge gave them the opportunity to do so in the interest of judicial economy and resolving these cases. And that type of behavior should be encouraged. That ends lawsuits on a friendly note. So with that, I see that I'm out of time.
Counsel, I have one last question. I'd like to circle back. You mentioned Jenner and Block and sort of took me down memory lane because I worked at Jenner and Block, and Jenner and Block did a lot of pro bono work, maybe the most in the whole country. I think at that time, maybe now, I don't know. And I did pro bono work when I was there, criminal defense work, including representing somebody at a trial. I'm still trying to understand your position that the court shouldn't consider at all the pro bono nature of the representation in determining what's a reasonable attorney fee, because we don't usually take away from trial courts. It's sort of like the res gestae rule in the criminal setting. We usually want the court to know the full universe of what's going on so the court can make a sound judgment. And from my experience, pro bono cases aren't always staffed the same way that regular billable cases are, in various ways. Sometimes more hours are put into them by more junior people who have less experience. Sometimes firms have some incentive maybe to puff up their hours so they can report more pro bono hours. I'm not saying that happened here or in my experience in the past, but there's different things that might go into the accounting for pro bono hours that are different because those billable records aren't sent out, they're not vetted by the client, and so on and so forth. So why in the world would we want to say that judges can't consider at all the pro bono nature of representation when determining, in conjunction with all the other purview factors, I guess, whether it's a reasonable fee? And I don't quarrel with the notion that there should be a fee, but I'm struggling as a former trial judge with the idea that we should tie the judge's hands in this way.
So I would respond with a few points. First, there's no statutory basis for that distinction, and I think that would be the starting point for the analysis. The statute says prevailing party gets fees, partially prevailing party gets...
That's kind of weak, right? Because the statute doesn't have all the factors in purview or lots of other things we think about, so
Sure.
what
So
else do you have?
That leads to the second point, which is there's no common law authority that suggests that a trial court can reduce an otherwise.
Surely there is. The common law authority would be that trial courts get to consider everything unless there's a specific rule like the one you're trying to get us to put in place that says you can't think about this. So
Well-
surely the common law history is that courts could consider everything before them unless there's a specific reason for them not to consider something.
So I think the important piece that Purgu recognized was that those other considerations have to be relevant. And there isn't a single case in the country, in any of the 49 other states, or any federal jurisdiction that says pro bono representation is a relevant consideration. This would be an absolute.
I don't know that any of the cases, I haven't read all the ones you cited, and I will, but I don't think those cases say what you're saying. They say you can't make a decision solely based on this one factor. Okay, well, I can concede that point. That doesn't mean it can't be considered in conjunction with all the other factors. I just don't understand why you're going so far with your argument. The notion that it shouldn't be the deciding factor, it alone doesn't justify a radical lowering of the attorney fee is a reasonable position. I think you're overreaching a bit. But anyways, we appreciate your responses.
Thank you, Your Honor.
Good afternoon. Good afternoon, and may it please the Court. Assistant Attorney General Adam Dep't, along with Solicitor General Ann Sherman, appearing on behalf of the Department of Corrections. This Court should deny leave for 3 reasons. First, in their complaints, plaintiffs demanded, and I quote, complete unredacted copies of the video. Plaintiffs consistently argued against the Department security concerns and moved for sanctions when the Department fought for its ability to produce the videos with redactions. In the end, the trial court did recognize the Department's serious security concerns and permitted the partial withholding of the videos in redacted format. And the fact that plaintiffs abandoned their efforts to seek unredacted videos at the last minute doesn't all of a sudden transform their partial success into a complete one. Ultimately, plaintiffs prevailed only in part, and their arguments to the contrary are plainly contradicted by the record. Second, the trial court below did abuse its discretion in failing to follow the framework set forth by this court in Smith and Purgu. But it didn't abuse its discretion simply by considering the pro bono nature of plaintiffs' representation. In fact, the legislature provided the trial courts with broad discretion in deciding whether to award partially prevailing parties with reasonable attorney's fees. And simply put, whether a party's attorney represents to the court that they're taking on the representation free of charge is, at a minimum, a reasonable factor for this or for the trial courts to consider. Accordingly, this court should refrain from limiting the trial court's discretion in deciding whether to award partially prevailing parties with reasonable attorney's fees. Third, plaintiff cannot be entitled to punitive damages where the department's nondisclosure was principled in nature. Specifically, the department and its members were threatened with bonds, guns, and poison as a result of the underlying debt or fight that led to the death of a prisoner. Further, a departmental inspector testified regarding the reasons that the disclosure of internal prison videos jeopardizes prison security. Accordingly,
Can we start with the prevailing in part? So my understanding, and I think it's close to what you've just said, is that the trial court ordered that it all be turned over. That was the original direction from the trial court. And then the videos were viewed in person after a request by the Department of Corrections to blur faces. So then they viewed everything, and then they didn't object to that.
Well, just a brief correction, Your Honor, and I'm looking for the citation. So the trial court, in its August 28th, 2018 opinion and order, provided as follows. Because of the concerns with the safety of the unnamed inmate and of the MDOC officers, the videos may be submitted, meaning to the court for in-camera review, in a format that blurs or obscures the faces of the individuals involved. And the procedural history that happened below was simply that the department, meaning the Department of Attorney General, who was litigating the case on behalf of the Department of Corrections at the time, had no ability to turn around redacted videos in that short time span. And when it offered the trial court the records for in-camera review, the records being the videos, it notified the trial court that because of time constraints, I believe there was a either a 5-day or a 10-day order to produce the videos. The Department of Attorney General is unable to produce the videos in redacted format.
Okay, so after that time, was there an opinion, an order from the court to turn over redacted videos?
From that point in time, there was, and the record will correct me if I'm mistaken, there was an order requiring the Department of Corrections to produce the videos, and I believe it may have mentioned the fact that there were no efforts made to blur or otherwise obscure the faces. And that most likely would have been the April 2019 order.
That's the final order.
Well, the final order in this case is the order that after the department moved for reconsideration and said, trial court, we notified the court that we weren't able to produce the videos with redactions and we would like the opportunity to do so. That was the final order. The court in that order said that the motion for reconsideration was denied, but even though it styled it as an order denying the motion for reconsideration, it in fact granted the motion for reconsideration because it permitted the department to produce the videos with redactions.
To the court for in-camera review.
So the court reviewed unredacted videos, but this permitted the production of redacted videos.
Because that was agreed to.
No, it was moved, the department moved for that relief.
And it was denied, but then there was in-camera review with no redaction. And after viewing the video, there was agreement, right? That the faces could be blurred.
So
It wasn't ordered by the court.
Well, I beg your pardon, Your Honor. What exactly wasn't ordered by the court? I just want to make sure I understand your question.
There wasn't a final order for the Department of Corrections to turn over redacted video. The order was to turn over the videos. And then the department asked for reconsideration to blur faces. They couldn't turn those over to the court for that in-camera review with them blurred. So what was viewed was the full video by both parties, correct?
So the trial court for its in-camera review reviewed unredacted videos. Actually, I believe it was the special master that did the review in this particular case. And then as far as what the parties reviewed, specifically the parties' attorneys, it was attorneys' eyes only. The parties' attorneys reviewed both the redacted copy that the Department of Attorney General was ultimately able to apply redactions to and an unredacted version.
And then the attorneys agreed that the redacted versions were fine. So that was never ordered by the court. There was never an amendment to the first order to turn over the unredacted videos.
So I do think the first order was that August 2018 order that was specifically the order denying in part, and I think it denied in part both parties' motion for, it certainly denied in part the department's motion for summary disposition. In that dispositive order on the motions for summary disposition, that's where the court said that the department could produce the videos blurred with the faces obscured. So that was the order on the party's motion for summary disposition, and that was August 28th of 2018. Following that, when the department produced its videos, that's when it notified the trial court and said, trial court, there wasn't sufficient time to apply all these redactions. In fact, in the record, I think it took 75 hours to apply those redactions to the videos. There wasn't sufficient time to get those done in advance of producing the videos for in-camera review. But yes, the first order on the issue of whether the videos could be redacted or non-redacted was that August 28th, 2018 order, when the trial court said that the department could produce them with the faces obscured or otherwise redacted.
Okay. So let's just talk about prevailing in part and prevailing in full generally. So if it, in the complaint, whatever is asked for, if that is not what is ultimately ordered by the court, then you have not prevailed in full. You've only prevailed in part. Is that your position?
Correct, that the plaintiff sought unredacted videos and obtained redacted videos. And conversely, that the department requested relief in the form of do not disclose the videos, but only received do not disclose the faces and identity of the involved inmates and responding corrections officers. That's what the department's position is with respect to prevailed in part.
So a party has to make sure that in their complaint, they're asking for no more than what could ultimately be ordered at the end. Otherwise, they don't prevail. I'm having a hard time finding when a party is going to prevail in full if there's anything that is kept out of that original FOIA request.
Especially when FOIA requests all the time have some redactions, like it's state government or local government, and there's lots of things that don't have to be turned over, but, you know, an average citizen who's not a lawyer makes a FOIA request, and the answer arrives, and often there are redactions. So I'm having the same struggle I think Justice Clement is every time someone goes to court to enforce FOIA, if there's a redaction, then they didn't prevail.
Well, I think as is often the case in FOIA, it has to be on a case-by-case basis, because there's no real easy way to create a broad test that applies to every situation. And I think opposing counsel discussed the fairly allocable provision with respect to whether to determine or how to award fees to a partially prevailing party. And then in that example, in the Supreme Court's opinion in Kestenbaum, it was discussed specifically if the attorney's efforts in litigating the FOIA complaint on behalf of their client, if those efforts were fairly allocable to the results that were obtained, right, then presumably 100% of those fees would be fairly allocable to the success that happened. The difficulty with that test is it's just not supported by the plain language of the statute. And it's not supported by the clearest intent of the legislature's policy determinations in the FOIA, because the fairly allocable standard would transform 15240 sub 6, which says, if the public body or requesting person prevail in part, the court may award all or an appropriate portion of reasonable attorney's fees. 2, if the person or public body prevails in part, the court shall award an appropriate portion of attorney's fees. So in this particular case, the plaintiffs are the master of their own complaint. And the complaint, it wasn't the request, but it was the complaint that demanded, in its relief requested, complete and unredacted videos. And I think plaintiffs, particularly in this case, should be held to their word, where the department's basis for its objections were legitimate and serious security concerns.
So the issue was the use of the word unredacted in the complaint. So if they hadn't used that word in the complaint, they could have still fought for unredacted. But it's because they used that word in the complaint?
No, but I think the fact that they demanded that particular relief in the complaint and fought for I think when you look at the record in this case, you will see that the plaintiffs, in response to the department's motion for summary disposition, argued that the department's security concerns were wholly speculative and that there's nothing to support that disclosure would jeopardize the internal security of the department's prisons. And then when the department fought for its ability to keep those redactions, the plaintiffs moved for sanctions against the department, as opposed to if what they really wanted were just the videos and didn't care about the redactions, the plaintiffs would have had no particular objection to that form of relief. This entire litigation from start to finish wasn't just about disclosure of the videos. It was about the department's position that the videos, particularly disclosure of the videos, would jeopardize the prison's security versus the plaintiff's right to know. And at the end of the day, the department was able to prevail in part with its security concerns, namely...
But were they? Because it was really just the blurring out faces. It wasn't redacting, cutting pieces of the video because of things that it showed. Or let's say there was 20 different cameras and 5 of them showed things that could have been a security concern for the department, and the others were fine. I mean, we're talking about just blurring identity.
And the department submits, Your Honor, that the non-disclosure of the identities of the responding officers and involved prisoners was a serious or a substantial prevailment, not just a minor redaction that had no import. As I mentioned at the outset in my introduction, there were death threats that the department received, And when you review the videos, and I know they're not a part of this court's record, but essentially what happened in the videos, it's in the briefing, a prisoner attacked another prisoner with a weapon. And the prisoner who was attacked was able to fight that prisoner off, deliver a couple of strikes to the prisoner's head before corrections officers responded. And the department's responsibility is to maintain not only the safety of its own employees, but the safety of the people in its care and custody, namely the prisoner who acted in self-defense. And that prisoner's name is not disclosed, has never been disclosed, and it would have been disclosed if the plaintiffs had been successful in the relief that they sought, namely complete and unredacted copies of the video. And I'm not just trying to hold, or the department isn't trying to hold the plaintiffs solely accountable for their choice of words in the complaint. If it was really the desire to get just the videos and there was no care about whether to produce only a portion of the video that showed what happened, well, that would have been much clearer earlier on in the litigation. But the plaintiffs have pointed to no particular portion in the record where they said, Your Honor, we're not challenging the objections. The only point where that happens is at the 11th hour when they had the opportunity to review unredacted versus redacted videos and say, you know what, we're not going to go forward and seek those redacted copies or those unredacted portions of the video.
Only after they saw them.
Only after the plaintiff's attorney saw them. The plaintiffs haven't, and there has been no disclosure to the public at large. But yes, that was an 11th hour decision when the department was arguing all along that disclosure of those identities disclosure would jeopardize the ability of the department to maintain the safety and security of its prisons, particularly of the unnamed individual and the corrections officers who were involved in the response.
Thank you.
Am I out of time?
You are, sorry. And you are out of time as well. I apologize. The case will be submitted. Thank you both.